Morning, everybody. Daniel Sherman here. Hope everybody enjoyed the time change. I know we all love it. I'm driving back from Hopkins County. It's Monday morning. It's about 10:30. What I wanted to talk about today is probates and what it means to probate something and what an estate is. So the point of probating is when somebody passes away, all their property is put in front of the court for everybody to see, and the property is distributed according to the law or according to the will. Creditors have a certain amount of time, 6 months, in which to file claims against the estate, and then whoever is the administrator of the estate takes charge of the estate, gets the property, pays the debts, and then, if assuming that there's anything left over, distributes it according either to the law or to the will. So that's kind of a simplified version of what probate is. Now I want to talk about what is subject to probate. Typically, you only probate personal property, although there are circumstances when real property is subject to probate. And the reason for that is because real estate is all done through title. It's all done through the county clerk's office. And if there's a will, you file the will. That's your source of title. If there's not a will, you'll do an affidavit of descent, and that says who gets the property. Now, oftentimes, what happens is after that's done, the administrator will do a deed to the owners of the property after the person passes away. So there are certain things that are not subject to probate. So number one is going to be anything that's in survivorship. So that's going to be a lot of times life insurance. There's a named beneficiary. So that's essentially naming a survivor. If there's nobody named, then it goes to the estate. Another would, a lot of times, bank accounts, jointly owned vehicles, if they say or, and so if you're, whether you're married or got a spouse or a kid, if it's, for me, Daniel and my daughter Eloise, if it's or, I die, she gets the vehicle automatically, there's nothing to probate. So things like that, there's no reason to probate. And I always say a good estate, there'll really be nothing to probate other than maybe the claims and a few odds and ends things. So with probate, basically there are two different ways to offer something for probate. One is if there is a will, and that's called by testate. And then the other is if there's not a will, that's called intestate. So I want to address wills first. As an attorney, I recommend everybody get a will, even if there's no property to probate, because sometimes you just never know what's going to happen. You may not think you've got anything to probate, but a lot of times you do. I had a case once where we probated a estate, and thankfully there was a will. Husband, we dispensed with administration. Everything was pretty well co-owned. Well, about 3 months after we closed the estate, he got a check in the mail for almost $100,000. Apparently his wife had signed up for, class action lawsuit for hip transplants, and that was her share. And so we just reopened the estate and went through the normal probate procedure. So that's one of the reasons to have a will. Another reason is a lot of people don't realize that the law doesn't automatically give everything to your spouse, or the law doesn't automatically give everything to your surviving children. And I'm going to go over that when I talk about if someone passes away without a will. So doing a will, you get to express, hey, if there's anything to probate, this is who I want to the property to go to. You can do what's called specific bequests. That's where you name specific property to people. For instance, like sometimes it'll be a dresser or a bed or a chest that's, very sentimental, or a ring or a watch, and you leave that to somebody. They say specifically, to my grandchild, I leave this. And then there's what's called general bequests. So I leave whatever property, everything, the rest, residue, and remainder to these people. You can name just one person, you can name multiple people, you can name them if one person dies, the other person gets it. But the will is your chance to do that. The will is also your chance to name somebody as the administrator or administratrix, or really, because there's a will, it's executor or executrix of the estate. So there's no question as far as who you want to be in charge of offering the estate for probate. And, sometimes if you don't have a will, even though everything may be divided, evenly, and everybody's okay with that, sometimes you just get fights over who's going to be in charge, who's going to take it to court. And I always said this, that the people just, when people pass away, they're just, the relatives are just not, they're just not in their right mind. They're just not thinking. They're, encompassed with grief. And so a lot of times they make really bad decisions. They make very irrational decisions. And, they just want to fight. And so that's why it's very important to have a will. Because it tells everybody, hey, this is what we want. Now, there are specific requirements in wills. I really won't get too much into it, but it has to be executed in a certain manner. If you're going to do a will, please see an attorney. Do not get one online. I've had several of those kicked out because they didn't meet the formalities. So there's a formal process to do wills. I've got one right now that I'm probating. It was done correctly, but then now I've got to find the witness the will, and have them swear under oath that this was the guy, and he was of sound mind, he was over age 18. So please, if you're going to get a will, and really everybody should, pay the couple $100, go to the attorney, because you're going to pay $50, $100 online anyway. So just, we charge for a simple will a couple $100. So it's not the end of the world as far as prices. So just I encourage everybody, if you're going to get one thing in your life, just get a will. I had my will done, I think a month after I was licensed. I don't have to change it. I named, my wife, she was actually she's just my girlfriend at the time. I named her. Any children I may have, and if my wife died, my children died, or I didn't have any, then I left it to my niece, because that's really all I had. So that lets you tell people what you want, and in certain circumstances how you want it to go. Now, most people, unfortunately, do not die with a will. So they die what's called intestate. And a lot of people have a misconception as far as where your property goes. So I want to be very clear that if you are married, your surviving spouse does not get it all, especially if things aren't in survivorship. So assuming nothing is in survivorship and nothing is jointly owned, the spouse gets 1/2 of any personal property, 1/2 of any real property, and a 1/3 life estate in any real property. And I'm not going to go into the significance of that, but basically it allows people to not sell the property underneath the wife, because the wife has a life estate in all the property. So that is what the wife gets if there's no will. Also, the surviving children they share the other half of the personal property, the other half of the real estate. And the last thing you want is Junior fighting Mom for the house because you decided not to do a will. So please do a will. Also, if you have, say, 10 surviving children and 9 of them die, common sense you'd think, well, the only one that's left gets all the property. That's not the case. That person, if there's 10 children, gets 1/10. The other 1/10, the other 9/10 go to the children who died, their heirs. And so that's going to be their children, their grandchildren, depending on who's alive. And I've done some of these estates where a person who died late 90s, and there's great grandchildren, then you've got children that have died and grandchildren that died, and you've got to go through and go through the lines of inheritance and say, okay, now this person gets 164th and this person gets 132nd, so it just, that's why it's very important to do a will, and mainly because people just don't realize, your children just don't get it all, or, your spouse just doesn't get it all. And I've got one right now where, he was told not to do a will, and he thought his only surviving child was going to get it, and it turns out, he has to share the estate with his niece. Now that's obviously a windfall for the niece, but he legitimately, I have no doubt in my mind, he wanted it to go to his one surviving child, and his other child passed away, left a child, and so that's kind of where we're at in the estate. So please do wills. It prevents things like that. And if you don't do a will, the state of Kentucky will tell you how your property passes. I do want to mention one other thing, whether there's a will or whether there's not a will, to kind of offset some of the, I guess, bluntness if you don't do a will. If you are a surviving spouse, you do get a $30,000 personal property exemption set off on the side before there's any division. And if there's just only surviving children left, they get a $30,000 exemption. And what that does is that protects maybe some grandchildren from getting, the full share. The surviving children get a part. So there is that to consider. That's whether there's a will or whether there's not a will. So again, please get a will. If you don't, then there may something, maybe, and I know a lot of people, well, I don't have anything. Well, you just don't know. And that's why I told you the story of somebody that got a almost $100,000 check after she died, and nobody knew about it. I also say you may have cases. The reason you should do a will is later on there may be a class action lawsuit. If it's wrongful death is distributed by statute, but let's just say it's something that you don't know about and doesn't come until after you pass away. So just make sure you do a will, and if you do a will, then you don't have to worry about it. So that's my recommendation. Again, if y'all have any questions, comment down below. You all know my phone number. Y'all have a good morning.